COVID series that will span over the next 3 weeks. The live presentations of the CLEs in this series will be free to all registrants, and we encourage you to register for all of the upcoming events. These products will also be available for aftermarket purchase, but this particular CLE will be available as part of the COVID-19 package that the Florida Bar is preparing at this time and will be free for viewing in the aftermarket phase. Information on each of the upcoming COVID series CLEs is available on our business law section website. And we also invite you to visit our website's COVID-19 resource page that is constantly being updated. Please contact me with any questions on these CLEs or other resources. Now, this presentation is 1 hour, and we will open the floor for questions at the end if there's time. If you have a question, please use the question and answer box that you'll find at the bottom of your page. Our panelists include Steve Dupre, Darren Spielman, and Steve Blickensderfer. Steve Dupre is a shareholder at Carlton Fields in Tampa, and his practice focuses on litigation. Darren Spielman is a partner at the Concept Law Group in South Florida, and his practice focuses on intellectual property and computer law. He is also the current chair of the Electronic Discovery and Digital Evidence Committee of the Business Law section. Steve Blickensderfer is a senior associate at Carlton Fields in Miami, and his practice focuses on data privacy and cybersecurity. And he is the current chair of the Computer Law and Technology Committee of the Business Law section. This presentation consists of 3 sections, all centered on the concept of working from home during COVID-19 and beyond. Because it is anticipated that the practice of law will evolve as a result of the pandemic, we think the material presented will benefit practitioners now and in the future. Steve Dupre will begin with a discussion on being a persuasive advocate online. Darren will then address e-discovery considerations, and then Steve Blickensderfer will address some privacy and cybersecurity tips. And now we turn it over to you, Steve.
Thank you, Stephanie. You've spent years learning the art of advocacy if you're a trial lawyer or a litigator. You employ the art of advocacy in the courtroom, in depositions, in mediations, in trials. And every one of those forums is a 3-dimensional forum. There's space that you can use to enhance your arguments. You can move around the courtroom. You can take a dramatic pause, walk from the podium back to your table and bring something to the judge or to a witness. And you can stand in front of the jury. And remember this, your fact finders, your judge, your jury, they're watching the entire courtroom, that 3-dimensional space, and they're picking up all kinds of information about the case that nobody ever talks about. They watch the scowls, the frowns by the parties and so forth. COVID-19 has thrust litigators into a disruption. Advocacy, as we know it, is being disrupted because we're doing remote video proceedings and we've lost our 3-dimensional forum. We now have video conferences as the only way to have FaceTime with judges, clients, and witnesses. And what about depositions? No seasoned lawyer wants to do a remote deposition. Everybody believes they are more effective when they're sitting 3 feet away from the witness, looking them in the eye, and using facial expressions and nonverbal communication skills to make that witness feel uncomfortable so that they'll tell the truth. And many people are worrying about what I call distance cheating. By that I mean people communicating inappropriately with lawyers or others while they're being examined online. One lawyer I know has postponed every single one of his depositions and is hoping to wait out the crisis so that he doesn't ever have to do a remote deposition. Yet California has just adopted a rule that basically says any party or witness can elect to be deposed remotely if they want to, even if they've been commanded to show up someplace. None of us asked for this disruption. It's all pretty scary, and it's scary because we're in unknown territory. and it involves having to learn new technology. But remember this, disruption leads to innovation and new skills. Now, some may say, who's got the time to learn new skills? I'm too busy. Really? Of course you've got time to learn new skills. If you don't, you're probably making an excuse for yourself because it's outside your comfort zone. Well, get outside your comfort zone and make the time. This is mission critical for your clients, and it's mission critical for you, if you're going to serve those clients. And nobody can say today, when will we return to normal? I know we've heard some things from the governor yesterday that sounds like we're returning to normal, but I haven't heard courts canceling orders and things like that. And I personally believe that this technology is with us to stay, no matter what happens and when we come out of COVID. So you've got to learn how to advocate effectively in remote proceedings, and you've got to do it now. You've got to get ready to learn how to do this. I'm calling the skill set that is involved in this Zoom advocacy. What is Zoom advocacy? Well, it's basically adding two new skill sets to your skill sets. You're adding what I call broadcast advocacy, which is basically learning how to conduct remote proceeding technology skills and learning about broadcast advocacy skills. You've already learned some remote proceeding technology skills if you've learned how to do PowerPoint when you're making an argument. Well, I call this PowerPoint on steroids. To apply these new skills, you really need to intertwine them with all of your skills. And so you've got to take your existing advocacy skills, your existing technical skills, whatever they may be, and add to them your remote video skills and your broadcasting skills. Now, how do you learn broadcast advocacy skills? I mean, where's the book on that? Well, you don't need a book. Watch TV. Watch TV and learn what it is that screen actors do and broadcasters do and TV personalities do to be believable. And what they do, what they've tried to do, and what you've tried to develop as a trial lawyer is credibility. Credibility in the courtroom. Now you have to learn how to be credible on TV. You've learned credibility in the 3D form. Now you got to go to the two-dimensional form. What makes a TV personality credible? Well, think about it. Who do you find credible on TV these days? For me, it's Dr. Fauci. Why is he credible? Why do so many people find him credible? Well, his career is built on medical science and data. He doesn't exaggerate. He relies on evidence, fact-based evidence. And what does he give when he comes on TV that every trial lawyer yearns to be able to give when they stand up in court? He gives the appearance of sincerity. He gives the appearance of sincerity. When you look at this image, what do you see? What's your immediate impression, and why do you have that impression? Well, he's got a non-distracting background, for example. He displays calmness in this image. He displays confidence in this image. You need to be able to do the same things when you're arguing over a video conference. There are other broadcasters who have exhibited these skills over the course of time. Think about the two of the old-time icons, Walter Cronkite and Dan Rather. When you look at these images, and how do you react? What draws you in? Well, they're close-ups. They aren't, you're not way back in the background. You're drawn into Walter Cronkite's eyes. He's looking right at the camera. It feels like he's looking right at you. Dan Rather, he's using his hands. He's using his hands to display some point. Why? Because he can, because he's good at it. And you need to learn these skills. And what about the lighting? Before I said that, did you even think about lighting in these images? Probably not. But you would notice lighting if it was bad lighting, if you couldn't see the face. And I'm going to show you now a slide that I snipped from a trial that was going on Wednesday over YouTube through Zoom. And that trial displayed this person. This was one of the parties to the lawsuit. He's got a window open to the outside behind him that is completely masking his face. Does he come across as credible? When he testifies, do you think the judge is going to be perturbed by the fact that she can't see his eyes? You bet she will be. Lighting enhances advocacy if the viewer doesn't see it and instead focuses on the image of the person who's doing the advocating. So if you learn only one thing from my presentation today, I would ask you to learn this. Learn to minimize distractions. What distractions am I thinking about? Well, anything in your screen image that might prompt a judge or a witness to stop listening to you, to stop watching you, to daydream, to wonder what that odd thing is on the wall behind you. All of those are distractions. I put together another slide here that has 2 slides from a practice session and 1 slide from that trial I talked about. So these are the practice sessions, and the third one there is the actual hearing. What's wrong with these pictures? Well, it's obvious what's wrong with these pictures. One lawyer wasn't paying any attention to what his image looked like, and so he's leaning forward, and you can't even see him. He's got his head practically on the camera. In the lower right, you see him using a virtual background that makes him virtually transparent. He looks like a ghost. The virtual background plays on his chest. And the guy on the left, that was an actual hearing. He was an advocate. He was listening to his adversary's argument. And what happened? The guy ducked down below the desk at one point because he was looking for something. He didn't have it at hand. And this was a complete distraction. It was like he disappeared. And then, of course, there's the light right behind him. You don't want to do that. You don't want those distractions on your screen. How do you avoid this? Well, you need to develop 2 skills. One, you need to develop a keen eye, and you need to be able to figure out what are the distractions in that picture. What's wrong with this picture? Look at it and fix it. And the other skill that you need to learn is to master the video app that you're using to technologically broadcast your advocacy. Learn how to navigate the app. Learn how to make the argument while you're using the app. And this will at least reduce the risk of tripping over the app in the middle of your argument. So how do you master an app like this? Well, even if you think you're a quick study, you're technologically proficient in many other ways, you're facile with most technology, don't assume that you are going to be able to figure this out on the fly. If you think otherwise, you're taking a huge risk because this is a feature-rich app and you need to learn its features to avoid making mistakes. But if you're up to taking this risk, let me just suggest that you are very likely going to demonstrate the true meaning of the 3-syllable version of the word assume. You'll have to teach yourself to manipulate the technology by practicing doing just that. Now, there's plenty of study materials out there. There's YouTube videos, there's support for the app, there's webinars like this. We've even given you a handout of tips that I've collected and others in my firm have collected over the last 6 weeks or so, going through various video conferences. You're welcome to use it to your heart's content. But learning those things, reading, isn't going to get you all the way home, because this is an app that you can only learn one way. That is, you can only learn it well enough to advocate with it one way, and that is what I call hands-on learning. You need to become facile with the program and get your hands dirty playing with it. Now, Zoom, the app we're using for this webinar, has a very useful tool that I would urge you to practice with. When you open up a Zoom meeting, when you open up the Zoom app, you've got choices. You can click new meeting and you don't have to invite anybody to it, and you can run most of the features in the meeting just by going into this new meeting. But you should learn all of the settings, learn how many there are. And if you hit that settings button, you're going to find 11 different categories of features, each one of which has a dozen or so choices that you can make in a meeting. So learn how to do this, practice with it. And the one last thing, you should, when you're learning it, you should hit the record button. Practice it. See what you look like. See what your background looks like. See how your slides show up and so forth. All of those things you can do with this app, and that's the fastest way to get good with this when you're trying to learn how to use this. And you're not going to get comfortable with this app until you practice and do it. Take a lesson from show business. In show business, particularly live theater productions, there's lots of rehearsals. The dancers, the musicians, the stagehands, and the actors all rehearse. But then when you get close to the production time, the stage manager takes over the show. The stage manager goes through every aspect of the show and 1 minute at a time, and writes down the technical cues, when to turn the lights on over here, when to turn the lights on over here, when to bring in the backdrops and when to bring in the sets, and calls all of those out backstage where the audience never sees it, so that those cues are hit every time. And the way they get good at that, the way the actors get good at that, the way the stagehands get good at it, is they conduct what's called a tech rehearsal. A tech rehearsal is where they literally go tech cue by tech cue with the actors and the musicians until everything has been practiced. It's usually the penultimate rehearsal before a show opens. So you can take a lesson from that. And when you build your argument materials and your argument outlines, however you do it, whether you list an outline, whether you just have pieces of paper that will trigger what you want to do, all you need to do is make sure you write the tech cues. If you're going to share a screen and you want to only do it for a moment so that you become the featured speaker on the screen, that's fine. But you've got to have a tech cue to remind you to take that screen down, or it's just going to sit there. It's just going to sit there. One or two other points. When you're in a broadcast mode like this, you're practically sitting on the judge's lap. You're in court. You've got to act like it. You've got to dress like it. Not just from the waist up, by the way. You've got to dress like, you put on, this is your costume. This is your performing costume. Wear it like you're in court, because that's where you are, functionally speaking. And when you're talking, use your screen image to convey both verbal communication and nonverbal communication. Connect with the judge. There's a trick to doing this. You've got to look into the camera. When you look straight into the camera, you're looking right at the judge if the judge is looking at you. And the judge may not be looking at you. But you don't control that. You can only control what you broadcast. So do it this way. Look in the camera and argue to the camera. You can sometimes put the image of the judge just below the camera and argue to the picture of the judge just like you're in court, and maybe you'll even pick up some cues. When you're not talking, mute your microphone unless you have to be ready to make an objection. Minimize your facial expressions. That means no frowning, no head shaking, no appearing indignant or swearing under your breath. Keep as still as possible. Be professional about this so that the judge doesn't get irritated with you because you're making all kinds of movements on the camera while your opponent is arguing. Two more points. Always have a low-tech backup plan for anything you want to show the judge in a video conference. And you need to do this because I've learned the hard way over a long time that all technology fails, and they fail at the most inconvenient times. They give they give new life to the meaning of Murphy's Law. So send your hearing books, send your PDFs, whatever it is you want the judge to be able to look at, so that if you can't make the technology work, you can't share the screens, you can't figure that out, you can point the judge to the book, tab 1, tab 2, and the judge can go through that with you. And one last point here, don't let this technology distract you from your advocacy. You need to continue, just like you would in court, to listen to opposing counsel, to listen to the judge's questions, and adapt your argument to meet that new information that you're being provided by the judge. This may require you literally to jettison much of what you plan to argue and much of the technology stuff that you plan to submit. Don't worry about it. If that's what you've got to do to be the better advocate, disband it, jettison it. The theme here is be prepared. Don't be the guy that comes into court and shows up literally with no pants on, because that guy is not the guy you want to be you. You want him, you want that guy to be the other guy. Don't let the surprises happen. Remember, video conferencing is actually embedded in the existing Florida Rules of Civil Procedure, Rule 1.451. Stay safe. Take time to learn this. It'll pay dividends as you go forward. And now I'm going to turn this over to Darren.
Great, thanks, Steve. I really appreciate it. Hello, everyone. My name is Darren Spielman, as Stephanie introduced before, and I'm the current chair of the Electronic Discovery and Digital Evidence Committee in the Business Law section. And to perfectly transition from what Steve had just discussed, even our group right here today spent some time yesterday practicing and finding out how this technology was going to work for us to do this presentation. And as a result, we learned quickly that we were going to need the host, who has control of the slides, to actually be doing it. So I'm going to continually ask Steve to advance slides when I'm ready to go, because I don't currently have control of it. Just to give you a perfect example of the kinds of things that you would need to anticipate. So what we want you to focus on next is e-discovery and digital evidence, and the things that you're going to need to consider moving forward, both as an attorney for your own practice internally and for your clients, and things that you're going to need to determine both for your clients and your potential adversarial parties. So first slide, please, Steve. So the first thing I want to talk about is technology measures. And a lot of what I'm going to do is really talk to you about questions that you need to be thinking about and topics that you need to be considering as much as possible right now moving forward. First, what technology measures do you actually have in place for your practice to ensure client confidentiality and to ensure the proper handling of sensitive client information? So I do a lot of intellectual property law, and I have to handle very secret and sensitive information for patents and trade secrets. But your client's confidential information is just as important. And how you manage that information, even how you manage your own law firm's information, is really important. What are you doing to actually store that data or specific documents? So you had a process when you were in your physical office, a document would come in, it would maybe get scanned, maybe you're not scanning it and you're still just using paper. But either way, what did you do with those documents and those things? Well, now, where are they being stored? Are they still being stored at your office? Are they still being stored at on a server that's connected to your office? Or are they being stored somewhere locally? Are they being stored on your physical computer at your home or at your desktop? And by the way, same questions go to, what are your clients doing? Where are they storing that data? What are they doing with the information? Consistently, we have found that attorneys mishandle or inappropriately store data in the wrong place or the wrong way when they work outside of their office. And this is because you're outside of your normal environment. You're not used to what's happening, and you take a shortcut because you're like, oh, I'll get to that later. Except now, every single thing you do is outside of your office. So you have to start making sure that you handle that data appropriately. Both bar ethics rules and just for your own moving forward, you need to make sure that you're doing the right thing of how you manage data in your law firm and how you manage data for your clients. Here's some questions that I want you to be asking yourself when you're thinking about this and when you're thinking about dealing with your clients. Who actually has possession, custody, and control of that data? That's a really important thing. And if you don't know even how to find that out, that's even more important. You need to find that out. And you need to start thinking about how you're going to ask the other side for that same information when you start sending out discovery requests. Next, are there actual policies in place for remote work? Some companies already had that. Lots of big law firms already had stuff like that ready to go because they have multiple offices. But if you're a small office and you didn't have that, you need to create a policy now. What about if you were using a function or a piece of software like Zoom or like Slack if you're having a communication tool? What policies do you have in place to manage how those communications are being handled, and what are the policies and procedures that go into using them? Also, what about preserving data? What policies do you have for actually preserving data, or more importantly, what policies do your clients have for preserving data? Remember, there's rules that once the litigation begins or is anticipated, that there's a preservation obligation. Well, what are they doing when they're working from home? Or what are you doing when you're communicating with them while you're working from home? It's important to know that if they're using their own home devices too, tablets and cell phones or a MacBook or a desktop, those are all important things that you need to know. How are they being preserved? Are there backups happening? What are you going to do when you're ready to ask for discovery? How are you going to know what to ask for if you don't have a set list of policies and procedures in place? Also, what efforts are being done to actually identify and implement, or actually start for the very first time, an actual document destruction policy? If you previously didn't have one, or if your client didn't have one, what are you going to do? Are you going to go through the process of alleging, oh no, we've always had a document destruction policy? Really? You better make sure that there's a written one ready to go and that it's actually being followed, or that it's going to be adjusted for the new reality post-COVID. Next slide, please. Okay, so here are some sources that you need to be thinking about when you're either crafting discovery requests or when you are receiving them. And these are the conversations you should be having with your clients now. Start that conversation now. Personal devices. Everyone is likely using a personal device. Most of the time, there's not company devices available, which often happens even when companies do allow or provide some devices. They still have what they call the BYOD, the bring your own device policy. So a lot of people still have their own personal cell phone. They just remotely connect to their email or even to some of the office server or software. But there's a different policy for each kind of device. And what is in place right now? What is happening right now to make sure that there's actually people following and knowing what software is being used, what devices are being used, what hardware and tools are being used. And like I said before, where is it being stored? If it's being stored locally on their actual C drive, on their desktop, for instance, at home, you're going to need to know where those places are, and you're going to need to ask the other side or even your client to give you a catalog of where all that information is located. More troublesome is, are the employees storing these things locally just because it's difficult? Are they trying to shortcut through? Or did your law firm, did you actually set up proper procedures so that you could store it still back on your servers? And lastly, in this section, I really want you to think about communication tools. So are you using, or are your clients using, consumer level communication tools? Talking about WhatsApp and Facebook, things that are not necessarily designed for business to business, things that are not set up so that you can have reasonable ways of storage and backup and monitoring and control. Those are typically free and typically being used by consumers just to communicate for social reasons. I'm not convinced yet that those should definitely be used for business reasons when you're talking about those types of topics. However, you should know that that's probably what's still happening, and you have to start crafting discovery requests for those reasons. Next slide, please. These are additional sources of, wait, I think we missed one slide. Can you go back one, Steve? Yeah, sorry. The additional e-discovery sources: software, social media, apps, platforms. And we really want you to be thinking about all of them: Facebook, Skype, WhatsApp, Snapchat, Instagram, TikTok, LinkedIn. These are all things that we all use constantly, but a lot of people don't use it a lot during the day. But since they're all home, they're using it all the time because maybe their boss isn't looking over their shoulder. Well, that information might have a lot of data about when they accessed an app and where they physically were. Maybe they were in Miami when they were supposed to be in Orlando, and their physical location is tracked based upon when they access that app. Your clients need to be aware, and you need to be aware of the terms and conditions that are built into each one of these platforms, each one of these pieces of software, because those are going to dictate how that data is being managed, stored, saved, used, and even potentially deleted. And that's important for you to know because timing might matter. You might need to be able to get that information and it might be gone. Access to that information during e-discovery, each one of those platforms has different types and ways for you to get it. So for instance, some of them have password protections in place. Some of them do not allow you to have a remote collection of data. You have to know now and have to start deciding, are you asking your client or are you asking the other side, did you use a VPN connection, a virtual private network? Did you use a private connection to connect to your server back at your office? Or were you doing everything back in your home? And how do we connect to that? Next slide, please. Okay, so let's talk about the actual discovery process. So let's say we've maybe decided where the information is and we maybe even got it. Now, you're going to have to make the choice, and we've pushed this a lot with the judges. We spend a lot of time as the e-discovery committee, and we educate and provide CJEs for the judges across the state. And what I can tell you is that again and again, we push the concept that you should start using vendors and e-discovery tools. Vendors are becoming essentially a best practice at this point. You're not going to know every nuance of computer law, and you're not going to be able to keep up on all the changes, but a vendor will. A vendor will know exactly what they need to be able to do, how to collect it, and to collect it in a meaningful and fast way. And importantly, a vendor will help you be able to provide authenticated collection. The key for you moving forward is making sure that you can actually provide real authenticated evidence to the court, to the judge. And you don't want to be the witness saying that you're the one who captured it. Use a vendor. There's plenty of very good ones out there, and they range in prices. I've always heard that it's too expensive, and my colleagues and I always say the same thing. The prices have dramatically gone down, and your client should be able to afford that without much frustration. Don't forget, just because you're still using a vendor, you are not relieved of your obligation under the Florida bar rules for technology competency. Just like Steve talked to you about before regarding the use of technology, your use of technology extends into your understanding and use of e-discovery. You are not relieved of that obligation. In fact, that obligation is going to become even more and more important starting during this COVID crisis and after. Because after this crisis, when you want to ask a vendor to help you gather e-discovery information, there's going to be a question posed of whether or not someone is going to let that vendor physically show up to someone's home if they haven't reopened their business, or even go into their business and what's going to happen. So additional considerations that have started to come up are using contact list collection of data, using remote collection of data. But the only way you're going to be able to know that is to be asking the right questions, to be asking, hey, how are we allowed to use this information? Are there password protections built into that business Do we need to get administrators or website administrators or network administrators involved to be able to let us get that access? All important considerations that you have to start thinking about. Next slide, please. So the number one place that everyone always complains about, even before this crisis, is cell phones. Everyone's cell phone is a hotbed of information. It is filled with data, and it is used all day, every single day. The same thing goes with tablets, but we'll focus on the concept of cell phones. This is the number one question that we get asked during our lunch discussions with the judges. They always want to know, well, what do we do about cell phones? Getting a mirrored image of a cell phone through a proper vendor is not expensive and is easy, but there's a lot of considerations. There's a lot of important things that you have to think about and that the case law has already started dealing with in Florida. First, by the way, each one of these that I'm talking about is based upon a specific appellate court case in Florida, and it's in the materials that you were provided. I'm not going to give you the case name, so I don't want to waste time because we're short on time. But it does address these topics. One, what is the actual scope of access to your device? Number one complaint is, I'm not just turning over my cell phone. That's ridiculous. The courts have already dealt with scope. Second, what about irreparable harm if you were compelled to turn it over? The courts have dealt with that. The cases cover that. A right to privacy. Oh, I have important private information on here that you shouldn't have access to. Good vendors will be able to segregate and only target the specific information that you're looking for. And lastly, expert collection. Just like I said before, you want expert collection for proper authenticated use. There's different challenges that happen with cell phones, with e-discovery in general, but let's focus on cell phones. The key is we're looking at preservation, collection, processing, review, and production. That's the flow. That's the actual flow of what happens. And each one of those steps matters. So we're thinking about, is your device the source of actual unique data? Is that where you want to be looking? Can you sequester the device? Can you turn that device into airplane mode so that it's not changing any of that data and still get what's on there? Is there a piece of software that's available to do the job so that you don't actually need to take the whole device away from someone for a long period of time? You want to hire a professional to do it, and you want to know that there's lots of really good pieces of software out there and vendors that can help you go through that process. Next slide, please. And then lastly, in the last bit, I want to talk about how the judges have been handling this and what some of the procedures are in court. So first, case management reports. You should take control. You should start providing and asking for status conferences or case management reports to the judge or to the court. A lot of courts are requiring it. Happens plenty in federal court, in state court not as much, but your ability to provide an early case assessment or an early case management up front with these ESI considerations is going to pay huge dividends in the end for you. Given the fact that we are all home and all working remotely, business too, your clients as well, you cannot allow and you should not be a person who ever again objects to discovery requests or has a meeting with your opposing counsel and says, yeah, I don't think there's going to be any ESI here. That objection or that position to the court is going to be gone. Everything now during these couple of weeks and maybe even potentially moving forward for another couple of months has an ESI impact. There's almost no chance that there is not an ESI implication built into what's happening. Just as an example, in Palm Beach County, in the 15th Judicial District, a number of judges have ESI standing orders or protocols already in place. Judge Burton and Tickton and Coates, they all have standing orders. Some of the judges don't, but you should make sure you see if a judge does have a standing order, because it will be extremely helpful to you to be able to point to the judge's order for your opposing counsel and say, hey, the judge already has this, we have to deal with it. And then the last little tidbit for those of you who are in federal court, like me a lot of times, you should expect that you're gonna see a lot of FRE 502D orders coming into play. I know I'm short on time, so I'm gonna pass it off to Steve Blickensdorfer, make sure that we can round it out and leave time for questions in the end. Thank you very much.
Thank you, Darren. Hello, everybody. My name is Steve Blickensdorfer. My practice focuses on data privacy and cybersecurity. And so I'm going to be focusing that conversation today or driving that conversation today how the impact of this COVID-19 quarantine situation has impacted your practices, and what you could do from a privacy and cybersecurity standpoint to improve upon both the privacy and cybersecurity. So first things first, let's talk about some ethical considerations when using technology at home. When you signed up, you probably went to the Business Law Section's website. We have 3 separate handouts for the various parts of our conversations. Highly recommend you take a look at those handouts where you'll see this slide, so you don't have to take notes, but it also provides links. But the first ethic opinion I'd like to discuss is 10.2. And this says that when using devices with storage media, meaning anything that can store data, and we care about personal data, lawyers have an obligation to keep confidences and remain current on developments in technology. And so this is supported by the Rule of Professional Conduct 4-1.1, competence, and 1.6, confidentiality. The particular concern here is when technology is discarded or recycled. That is when you're recycling your old cell phones, tablets, printers, scanners, digital printers and scanners, anything that can store data. Pretty much when the rule or the opinion came out, storage medium was not pretty much in anything, but nowadays everything can store data to an extent. But you need to keep that ethics opinion in mind when you are upgrading or changing your device. Securely, you want to make sure you securely wipe any and all personal data from your devices. If you're a solo, use Google as a guide. If you have an IT staff, ask them to help you out so you can make sure the devices that you're using to work from home are securely scrubbed. Next, ethics opinion 12-3. This one concerns the use of using service providers that enable access to a lawyer's files from any computer or device, i.e. cloud computing. And so you can use cloud computing. Think of Office 365. You're probably using it today. But the thing to keep in mind here is that you must take reasonable precautions to ensure the confidentiality of your client's information. Again, this relates to the confidentiality rule 1.6. So what should you do? Research the service provider, the cloud service provider, or any service provider you're using, and employ available technologies or controls to guard against reasonably foreseeable attempts to infiltrate the data wherever it's stored. And so we're going to get into a little bit of that in a moment. So I want to just round this off with the formal opinion from the ABA 483. Now this says what you probably already expected to say, which is a lawyer has a duty to notify clients in the event of a data breach. And we're oftentimes thinking about clients and them reporting about breaches that occur on their side, but lawyers have to be mindful that they may have an obligation to report as well for any security incidents that might trigger, in particular in Florida, we have a statute, section 501-171 Florida statutes, so it's FIPA, Florida Information Protection Act. And that requires notification to affected users or affected Florida citizens in the event of a data breach. So it's just something to keep in mind for Florida lawyers out there. Now, this formal opinion from the ABA is supported, as you can imagine, 1.1 competence, 1.6 confidentiality, safekeeping of client information and confidential records. Next slide. But now let's get talking about some of the cybersecurity best practices when working from home. First, you want to make sure you have your system is properly patched and that event logs are turned on. And so by patching, that refers to basically making sure you're working on the most up-to-date software. These are all forms, by the way, of cybersecurity controls. I might talk about controls later, but that's what all of these examples are. So applying necessary patches, this is important more than ever because hackers are exploiting patchable vulnerabilities most often. And so you can imagine if you're trying to defend yourself later, you took all the reasonable steps to make sure you were protected. One of the first and low-hanging fruits that you could do to demonstrate that reasonableness is that you applied the most recent patches that were recommended by your software developer or the software vendor. And as you can imagine, if you're working on Windows 10 or the most recent operating system of your particular computer, they pretty much have that turned on to go to show you how important it is to make sure your system is patched. So if you have IT professionals that you use, make sure that they put those settings on and make sure you're getting the patches. As for event logs, think about, there's a picture on the slide that shows you what an event log looks like. It's really nothing fancy, but it's just turning on records keeping system inside the computer. And that basically will help to keep a log of activity as it relates to whatever it is. If it's a network log, it shows the network activity and traffic, and it keeps it for a certain period of time. Now, you want to have this information because it helps to keep a record of who's coming in and out of your network. Next, you're going to want to remind your employees during this time to remain vigilant. Malware, ransomware, phishing attacks, they're all taking advantage of the fact that we're working from home. We're no longer sitting in our office down the hall from each other, and then we're more distracted, maybe by the news or other commitments at home. So you want to remind your employees and yourself to delete or report suspicious emails. Avoid clicking on links or attachments without checking their source, and confirm that if you're doing wires in your business, that wire payments are being routed through the proper channels. Now, when we're talking about checking links in particular, one of the ways, easy way to do that is just to literally hover over the link in an email, if it's a download or if a link to another site. And if you don't recognize where that's going, or it looks like it's an unfamiliar address, that is most likely going to be a suspicious link. You just want to delete that email, notify your IT vendor or your IT staff, and they'll take care of it. You also want to enable multi-factor authentication for system access, or really wherever it's available. The picture on the slide shows a representation of what multi-factor or two-factor authentication, as it's often called, consists of. You'll be on the first part, you'll be on the slide or the landing page to gain access to your system. You put in your username and your password. Well, the way two-factor works is that you have set up in advance to send or to give that particular system your phone number or another email address. And what happens is when you log in, it'll send a signal to that other location, your cell phone, for example, where you validate that you are trying to log in at that system access site. And then you click yes, if it's in fact you, and then it gives you access back on that system access site. You can use apps like Google Authenticator to access or to basically have two-factor authentication enabled on your favorite apps and devices. This is more and more common that apps are coming with that feature available, although it's often not a default. And it's so what cybersecurity professionals really love about two-factor is that it really reduces in a significant way the number of intrusions just by brute force attacks and just by copying pasting commonly used passwords and usernames. And so that's why multi-factor can be an easy way to just shore up cybersecurity in a meaningful way. As for wiring, I mentioned that before. If you do a lot of wiring at your firm, determine how to adjust the process while working from home. Maybe in addition to what you previously did, enable a video confirmation through an app like Zoom or any other video conferencing app. And organizations should also be sure, as we're perhaps remote desktopping in or using virtual desktops, but there's sometimes ways where you're working locally and also access to a system. You want to try to save as much as you can to the corporate system. Why is that? Well, IT staff regularly back up those systems, and at home you might not be backing up your system as often as those corporate systems are. You want to try to get in a habit of backing up your system more often, but at the very least, for a corporate, for the firm, the cyber attack in particular we're worried here is a ransomware attack. That's where your system is basically locked and you are demanded by the hacker to pay a fee to unlock it. And having a recent backup handy is the lifesaver in that situation. And so that's why you really want to think about backups and having a regular backup routine. And then when you're working remotely, working from home, try to see you operate as much in that digital environment as you can. Next slide, please. Ideally, the firm should have an incident response plan in place to be deployed in the event of a suspected incident. The image on the left shows the steps in a typical incident response plan. First, you prepare. Next, you identify the incident and determine whether it rises to the level of a breach that has to be reported. Next, you contain the issue, eradicate the issue, recover, and importantly, and this one is often overlooked, you take stock in what happened and you learn from it. You want to monitor through the use of logs the system usage, and that should be top of mind, in particular if you're perhaps an administrator at your firm or in upper level management. You want to make sure that the system usage is being monitored, and you want to keep an eye out for suspicious network activity. What you're looking for here is repeated failed login attempts, unusual login activity, or logins from IP addresses that are unknown. Oftentimes, these events will happen more frequently when working from home, as you basically are rolling out a work from home strategy to apply across the firm that hasn't been done before. That might result in maybe a spike in unusual logins. But once that normalizes, then you will have at least a repeatable pattern that you might be able to suspect new triggers or new information that might lead you to deploy your incident response plan and figure out if you have, in fact, an incident that you need to escalate. Basically, the global thought process here is think of all the various ways a hacker or a bad actor can infiltrate your system. They're clever, they're getting even smarter, and they're trying to find ways to trick businesses, and that includes lawyers as well. And final note on this before we move over to privacy, review your insurance policies. It used to be that we just try to fit in a cyber incident in a already existing policy. But at this point now, there are so many new riders and new policies that have been crafted to address the various types of cybersecurity incidents, ransomware, phishing attacks, social influencing kind of attacks, that you want to figure out. Obviously talk to your broker or carrier what are available, but you want to figure out what you have available. That way there's no surprises later. And you also want to know, and this is something that's often overlooked, your carrier or your provider through your coverage might have access to vendors, forensics examiners, that you will then have access to in the heat of a moment during an incident. And you want to know that in advance. And ideally, that information will be at the contact page at your incident response plan. Next slide. So let's switch gears here and talk about privacy. Oftentimes, there's an overlap between cybersecurity and privacy, but not always the case. So first, you'll want to think about your privacy practices and procedures. Working from home has resulted in the collection of new types of personal data and in new ways. And there are also increasing number of privacy regulations that govern personal information. Think about the California Consumer Privacy Act. And these regulations are increasingly impacting law firms, including those in our state. It's therefore important to be clear and conspicuous in our privacy about the use and collection of personal information. So where do you start? First, do you have an online privacy policy? When was the last time you took a look at it? Does it accurately reflect the ways in which you are handling personal information? If you don't have one, should you have one? Historically, you only needed one if your website collected personal information and you did business in California. Well, things have changed. Now, pretty much any business that operates online should have an online privacy policy. And yes, that does include law firms as well, because they are servicing their clients, but they're also capturing some data on the marketing side. And you might want to talk to your marketing folks to figure out what that looks like. Also consider your internal facing privacy policies. Does your firm need to update them to more accurately reflect the current working from home environment? Try to capture and create rules for the new data that's being collected by all the devices that Darren had mentioned before. What are the rules in place now, and what should they look like? Should they be updated? Now let's switch gears a little bit and talk about everyday meetings. You want to avoid things like Zoom bombing, where some unknown third party intrudes in a meeting and uses the screen share to share some disturbing content. How do you do this? Well, I've included a picture on the slide there to show that most apps, the ones you want to be using, will give you tools, and Steve showed how you can access that through Zoom, so you can edit the settings in advance. And that includes, what you want to do is try to set the meetings to be password protected, limit access by providing unique ID numbers for each meeting participant. If you're hosting recurring meetings, create new passwords for each one and unique IDs for each one. Maybe you want to lock the meeting before the host has joined, and so you can prevent others from joining, and lock it once it's started. And you want to be able to make sure you have the ability to remove users once the meeting has begun, should the need arise. On a related note, you want to also configure your own camera's privacy settings for the video conferencing app. As Steve mentioned, you want to test this stuff out. Check it to see if the video camera turns on by default and starts recording. You want to avoid that situation where you're being recorded or you're presenting as soon as you enter the room. Perhaps you can turn that off by default. Next, you want to check to see if your video conference is being recorded. Should be obvious. You should be able to see a bright red dot with the words recording or something REC like that's on the slide. But there have been reports of video conferencing that have video conferences that have been shared without the participants' knowledge or consent. The safest strategy, just assume you're being recorded, and if possible, avoid sharing sensitive personal information through a video conference. Next, you want to be careful to, before sharing your screen, make sure, as Steve alluded to earlier, you test it out and you know what screen is going to be shared. And some services allow the option to turn off screen sharing and allow the host to control that, and that's something that we recommend installing. Don't expect or don't open unexpected video conference invitations or click on links. This is something you should talk about when figuring out what you would like to do from a privacy and security standpoint. But hover over the link is the easiest way to figure out if malicious actors are sending you that email invitation instead. We're just seeing an uptick in that, and you and your employees have to be alert and vigilant about that. But in the interest of time, I will want to skip down and go to the next slide, Steve. For meetings that are particularly sensitive and where confidentiality is crucial, consider video conferencing may not be the best option. And you might want to look into enterprise services, which often provide greater security in the exchange of payment. Next, while you're doing your due diligence on service, you'll want to review key provisions of the service provider's privacy policy and understand the expectations of what information they're collecting and using, and that way there's no surprises. And that's actually what kind of got Zoom in trouble initially, is that there was some undisclosed sharing involved with third parties, and that was problematic and maybe problematic for many of you. So what do you do to avoid that? You want to take a look at the terms of service that accompany an app or program. And look at their privacy policy online. Does their policy limit the company from collecting or using your data? Do they give assurances about their handling and use of data? And next, you want to update your video conferencing software. Make sure you're using the most recent version. Zoom, for example, they patched their Zoom app but didn't force it on everybody, and that sharing turned off with that third party in the most recent version. So you just want to make sure you're using the most recent version and you accept those new updates directly from either your app store or the vendor's own website. Don't use it. Don't go to various third-party sites for that. And next slide, I just want to briefly go over we touched a little bit upon this, when you're working with working from home vendors, just some things to keep in mind. Understand what data you're sharing with them, what they're capturing on your behalf, and so that you can look for it in the terms of service and in the vendor agreement that you signed with them if you do sign one. If you're making new disclosures, you want to know that, or if you're collecting data in new ways, new data because you're using a new app and you weren't using that before, do you need to make new disclosures either to your employees or to your customers? You want to revisit your own privacy policy that we alluded to before to see if you need to make any new updates there. And you finally, and maybe the most important takeaway here, what happens if there's an incident involving the data that's collected or used by this vendor? What do you do? What happens in the event of a cybersecurity incident? Key here, look to the contract. That's going to dictate who has the responsibility of reporting. If the contract completely ignores that, you want to make sure that's in place and talk to the vendor about that. So that concludes my part of the presentation. And I'm sorry, we're right at the end of the hour here. I'm sure others are willing to stay for a little extra to answer some questions. Stephanie, would you like to perhaps take it from here?
Yes, thank you all so much for all that information. I know that we've already gotten some feedback that people are really appreciating everything that you've already let all of us know about this course. So does anyone have any questions that they would like any of the panelists to answer? And if so, if you could go to your question and answer box, it's down at the bottom of the page, and we can then field questions in that manner. All right. I know we had a question come through earlier that Stephen Dupre answered for us, so thank you for that. That was on our question and answer page. I'm not seeing anything come through as of right now, so is there anything else that any of the panelists would like to add for the CLE or any additional information?
Looks like there's 2 questions that have just popped up.
Perfect. Okay, the first one that we have is, do you have tips for minimizing distractions by others on Zoom while presenting?
I don't. I've tried to figure that out. I haven't figured that out yet. Maybe slide them off your screen so you don't see them. Or pin the speaker and just don't pay attention to them.
I have a tip I could share. I use an app on my desktop called Fences, like a fence around your yard. And it helps to organize my desktop. And it's got a neat feature when you want to clear the background, you can double click and it completely erases everything on your background to just be what you have open as a window. So if you, like me, have lots of stuff on your desktop, it can get cluttered and distracting. You could use an app like that to help you stay focused.
Wonderful, thank you. It looks like we've got another question here. What is the proper procedure for presenting witness testimony via telephonic hearing with judges who do not use video tech?
I've seen it done where you basically have to be methodical in identifying the speaker every time they begin speaking. Obviously, if you have a witness who's taken the stand and has been properly sworn under oath, which is an issue sometimes, then the judge is going to get used to that person's voice. But if there's multiple people in the room and somebody objects, you simply must announce your name before you object, or the judge may not figure out who's making the objection and the court reporter may not record it properly.
And I would add that it's not even just objections. Even just when you're on a telephone status conference call or a motion hearing with a judge and there's multiple counsel, identifying yourself every single time before you speak is critical, because we've seen it now recently where the judge goes, "I'm sorry, who just said that?" So even if you're not dealing with a witness, just you and the other attorney are on a telephone status call or a motion, you should identify yourself every time you speak.
Okay, it looks like
There's a question here about whether the witness needs to be in the same room as the court reporter, and I've seen orders come out, at least during this COVID period, where that is not necessary, but you do need, I don't know that you could do that telephonically. You do need to have some way for the court reporter or the notary to swear in the witness and be sure that the person who is giving the testimony is actually the person that is supposed to be giving the testimony. There was a video trial on earlier this week, and I watched them swear in a witness. They were broadcasting it on YouTube, and the way they verified it is he held his driver's license up to the camera, which from a privacy standpoint is remarkable, because anybody could have taken a snapshot of that screen and captured all of his personal data on the driver's license.
It's a good point, and it just goes to show you you need to constantly be thinking about, is what I'm doing private and secure? Because it's oftentimes we're doing it because we're just figuring it out as we go along, and we're not thinking about those privacy and cybersecurity considerations until after we've started. So it's a great example, Steve, of thinking about, this is what's being done, but we need to think about, is that the right way to do it? Is there a more safe and secure way to do it, particularly as it relates to our clients' data?
I was actually going to show a snapshot of that if I had time, but I didn't do it. The slide, however, I redacted his personal information.
Well done.
Thank you all. Do we have any other questions for our panel? All right, wonderful. It looks like we don't have any other questions at this time. If anyone does have a question that they would like answered, before we continue, it looks like we've got one more question that just popped up.
So let me speak to that, because, as I said, I was watching a live trial that was broadcast through YouTube via Zoom. And the court reporter was not in the same room as the witness. And the witness was at home. The witness turned out to be a party, and that witness was at home using his own computer. He had worked with his lawyer to make sure that his technology all worked. He didn't follow some of the rules that I've laid out sort of in my tips document, such as putting the camera at eye level so that he's speaking directly to the screen, as opposed to what he was doing, which was looking down or looking up. You don't want to do that sort of thing. You need to train your witness, but the witness was on his own computer. I'm not sure what is meant by we're on our own regarding all witnesses. One thing that the judge did before any witness testified was sternly instruct each witness: you shall not text, you shall not email, you shall not have a side channel open to communicate with your lawyer or anybody else, or to do internet research or any of that stuff. And I was frankly surprised at the ability of the cross-examiner to do an effective impeachment of this witness by reading his video testimony. But there's no question that he did an effective impeachment, because he posed a couple of questions to this witness, and you could just see on his face, because remember, you're sitting in that witness's lap too. You could see on his face that he was searching for an answer that he couldn't find. And when he gave the answer that he gave, the judge just laughed at him. And you could see that as well. A hostile witness, I'm not sure. You've got the courtroom clerk who's monitoring it, and the judge, will undoubtedly attempt to control the hostile witness. But fortunately, the hostile witness can't jump through the screen to beat anybody up or get physical, so they can't get too hostile. So the video setup that I have today was actually on one of my screens, the one that said hands-on technology. It's basically, I've got 4 reams of paper on top of which I've placed my laptop. And on the right, I've got a screen. On the left, I've got a screen. And it gets particularly challenging to run a PowerPoint slideshow when you're doing that, because you got to figure out which screen to share. And when you go to share screen, if you've got a lot of applications open, they're all displayed. You got to pick the right one. I watched a lawyer who was supposed to display a PowerPoint show at the beginning of an argument last week or the week before, and he clicked on share screen, and what did he pop up? The judge's bio, the judge's preferences, the picture of the judge, and it completely disrupted the start of his argument. A natural mistake. It didn't hurt him long term. The judge kind of laughed it off, but that's why you've got to practice your cues, so to speak.
All right, wonderful. Thank you all so much. We really appreciate your time. Our panel, you've been fantastic. If anyone has any questions after this, please do not hesitate to reach out. If you reach out to me, I can get you in contact with any of our panelists. I know that they have also provided emails, and I'm sure that they would be happy to answer any questions that come up after this.
Someone also asked if there's going to be CLE number for this.
Yes, and our CLE number for this is 3943. It's in the invitation, but I can also send everything out again just to make sure that everyone is able to get their CLE. It looks like we have one more question.
Resources for managing the introduction of documentary evidence in a virtual hearing. So if you're doing a virtual hearing, it's likely going to be a bench trial, and any judge worth her salt is going to require you to do some pretrial work to reach as many stipulations as you can make in order to eliminate all of the rigmarole associated with authenticating documents and so forth. But if you have to authenticate documents, the way I would do it is, number one, I would have my low-tech backup documents delivered to the court ahead of time so that the judge could see what the documents are, and then I would use some kind of an app to provide a copy of it to the witness. Since it's a bench trial, again, the judge may have to be able to see it. I don't know. I haven't figured all of that out. But once the witness authenticates it, you just do what you normally do, which is move it into evidence. If there's an objection, fine. If there isn't, then you can affix an exhibit number on it. All kinds of programs will let you do that. TrialPad in particular is a good one to be able to do that. But various court reporters have got programs as well. From a resource standpoint, you should check with vTestify, you should check with Veritex, you should check with Esquire, eDepose, US Legal. All of those companies will have some kind of a solution for you. And work it out with your court reporter in advance too. A lot more pre-planning has to go into this.
Wonderful. Thank you all so much. And with that, we are going to go ahead and end this CLE here. Thank you all and have a wonderful rest of your day.
Thank you.